Let's go ahead and start week 4 of the Business Law live meeting. And we're going to be discussing for the next 30 minutes Chapter 7 and Chapter 9. Now, you notice the author's title, Chapter 7, Marketing and Technology. And if we've noticed anything in the last couple of years, the introduction of the internet has totally changed all of the marketing techniques, really the basic business discussion throughout the United States, really throughout the world. That with the introduction of the internet, now individuals can buy products from companies all over the world. It really is a tremendous innovation and change in every part of our culture. And you notice the authors add to the title choice and manipulation. And we're going to talk about how we as consumers can be manipulated through the advertising that the various businesses conduct. And to begin this discussion, there is a constitutional issue that affects this area of business law. And as you see on the slide, the concept of commercial speech. And to give you a little introduction, we're all familiar with political free speech under the First Amendment, that you're protected under our Constitution. If you want to march up and down in front of City Hall and say the mayor's a bum and he's not worth anything and that we should get rid of him, and really you're protected as long as you're advocating political beliefs that you have. There's some exceptions to it, but generally the Supreme Court has protected pretty much the majority of the political speech. Well, the Supreme Court, after a few of the cases, has developed a protection for commercial interests, for businesses, and in their marketing, they have certain rights under the Constitution called commercial speech. Now, they are much more limited than the political speech that we spoke of. The idea being that because the company is trying to make money through this kind of speech, it's going to be much more limited than the political speech. And the first case that we have, IMS versus Kelly Adote, involves a company. IMS was a company that provided medical information regarding prescriptions, and they tracked which doctors prescribed which prescriptions and how did their prescriptions change over a period of time, and even had some information about their patients. Well, the information identifies by a not directly, but by a code, which doctors are prescribing which drugs to which patients. Well, the lawsuit arose because the state of New Hampshire passed a statute prohibiting this data from being used for commercial purposes. And under the state law, a company could not use this information for profit to sell it to individuals who might be interested in this information. Well, IMS sued, and it's interesting, I want to point out that you notice that the plaintiff is IMS. The defendant in this case is Kelly Adote. And I don't know if that's a man or woman, but they are the state attorney for the state of New Hampshire. And so that's why they're the defendant. They're not personally liable, but they are representing the state of New Hampshire in this lawsuit. The Supreme Court had a discussion of the commercial speech rights involved here. Does the government have a vested interest in keeping this information private and not allowing it to be used for commercial interests? The court held that the statute did violate IMS's First Amendment rights to their commercial speech and therefore declared the statute unconstitutional. So it's one discussion, an example of what we're talking about as far as commercial speech. Now, the authors give you an interesting article on page 239, and I want to point this out to you just to show how really interesting some of these cases can be. And the situation here is a brewing company, Hornell Brewing Company, in 1993 decided to start selling a malt liquor that they produced under the name Crazy Horse. Well, various Native American groups stated that Crazy Horse was a greatly respected Indian leader and that it was against their beliefs to have a beer named after Crazy Horse. And further, they brought up the situation which unfortunately exists in the Native American community, where there is a high rate of alcoholism among Native Americans. And the groups felt that this was abhorrent to their beliefs and that the company should be prevented from using this famous Native American's name. Well, the company, of course, sued and alleged that this was a violation of their commercial speech, of their First Amendment rights. And the court, in their discussion, decided that the use of the term Crazy Horse may not have been the most great example of marketing and offensive probably to many Native Americans, but the brewing company's commercial First Amendment rights were more important, and that they should be allowed to use this name even though it did offend certain Native Americans. So you can see where some of these cases really involve some interesting issues that we normally wouldn't think of. Now, I point out to you, the authors have a real good article that by John Kenneth Galbraith, who is a famous, I'm not sure if he's still alive, but he's a famous economist. And this is a very interesting article about the influence of marketing on consumers. And so I pointed out to you just for some additional information. Now, as part of the regulation of advertising in the United States, the Federal Trade Commission is the federal agency that is responsible for regulating advertising by companies. And the FTC investigates any claims of fraud or any kind of false claims a company is making regarding their products. And the FTC versus Suletta Distributors is an example of one of these cases. And the facts were the Suletta company started marketing a product with the claim that it would eliminate cellulite in people's bodies. And if you're not familiar with what cellulite is, it's a a fatty growth that comes in usually in legs and is very unattractive. And many individuals would like to eliminate that from their appearance. And Soleta was selling this product based on the fact that the product would eliminate this. The FTC investigated the claims. There was no valid scientific reason to believe that this product had any effect on cellulite, that it was fraudulent for Soleta to advertise that what this product did, and it was a violation of FTC regulations, and they were prevented from distributing and marketing this product with those claims. So the FTC does this all the time. You may have seen some articles in the paper or on the news regarding the FTC stepping in to prevent this kind of misleading or false advertising. Now, as part of the regulation of advertising by business, the Lanham Act was passed very many years ago, and it initially was passed for enforcement of advertising. But one of the results of the Lanham Act was that companies who felt that a competitor was making false claims about their product to try to damage them had a right of action against the perpetrator for the claims that they were making. And the case that the authors have brought up, which is a famous case, is the Pharmacia versus Glaxo. The GlaxoSmithKline. And in the case, the facts were that Pharmacia had a product that was used to prevent smoking, and that it was a product that it had developed to help individuals quit smoking. And the claim was by Pharmacia that GlaxoSmithKline in their advertising was claiming that their product was superior to Pharmacia's, that it could be taken more often, that more doctors approved of its use, and that they were making these claims in direct attack on Pharmacia's product. And you've seen these ads before where one company is claiming their product is superior to another, and this is what GlaxoSmithKline was doing, is trying to prove that its product was superior. So Pharmacia sued GlaxoSmithKline and was seeking an injunction to prevent GlaxoSmithKline from running their ads. And under the Lanham Act, they are legally entitled to an injunction if they can prove that the claims are false. And Pharmacia was able to prove that the GlaxoSmithKline product advertising was false, and that the claims it was making were misrepresenting its product and falsely attacking the Pharmacia product. And so they were awarded an injunction to prevent GlaxoSmithKline from running their ads. the an interesting sidelight to that, and the authors just give you a little small example of this, is there are certain situations where really the conduct of the executives in a company really went beyond what any beyond any decency or common any expected social conduct. And this involves the marketing of cigarettes. And we're all familiar with the situation involving cigarettes, that for many, many years, the executives at tobacco companies knew through their own research, through the scientists that they used, that cigarettes caused lung cancer that led to cancer. And they continued to sell cigarettes, continued to market them to individuals for many, many years, knowing that there was a danger in smoking cigarettes. Eventually, they were sued, and I don't know how familiar you are, but there was a large lawsuit against the tobacco industry that resulted in billions of dollars in damages for individuals the family of someone who had died of lung cancer and had been a smoker, or for those cigarette smokers who had contracted lung cancer, were able to recover billions of dollars in damages from the tobacco companies. And again, the basis of this even goes beyond what we've been talking about, that the tobacco executives knew that that their cigarettes cause cancer. And of course, that led to the FTC warning on cigarettes. Now there's the advertising of cigarettes on TV has been banned, and there is now a warning on any packages of cigarettes sold that state that cigarettes are a major health hazard. Now, the last case that the authors use as an example of market manipulation by advertisers, the misrepresentation of a product, and much like the tobacco story, the Sarah Perez versus Wythe case is an example of this. And in the Sarah Perez case, Mrs. Perez was a female who was among many other females who had sued the Wythe company. And Wythe made a contraceptive device called the Norplant that was inserted into the female and was a contraceptive and was marketed and advertised by Wythe that it would prevent pregnancies. And the Wythe company made extensive advertising in, of course, women's magazines, even, I'm not sure if there were television ads, I can't remember, but they marketed this device to females for contraception. Now, the interesting twist in this case is an interesting legal concept that for many years, as you all remember, drug companies didn't advertise to the public. That drug companies marketed their product by contacting doctors and urging these doctors to prescribe their medications for the various illnesses and conditions that they were treating, and that there really was no direct contact with the public. Well, years ago, this changed, and of course, we're all familiar with the drug ads now on television and magazines in all kinds of media where the drug manufacturers are contacting the public directly to market their products. Well, under the old system, drug companies were protected from any lawsuits regarding defects in their products, because they were only advertising or only contacting doctors. And the legal concept in the case that the judges discussed was called the learned intermediary rule. And what this meant is that because the female patients were contacting and dealing with their doctors, the manufacturer was protected because they were relying on the knowledge and learning of these doctors in prescribing any of their drugs or medications. The court discussed this. This was a defense that Wyeth had alleged, and stated that now, because companies like Wyeth were directly marketing their drugs to individuals, that the learned intermediary rule did not apply, and that they should have stated in their advertising the warnings of side effects, that many women were having serious side effects, bleeding, many side effects for the use of this Norplant contraceptive. The evidence even showed that in many cases it was difficult. A doctor had to insert the device, but that there were difficulties in them removing it, and that many women were injured by removing these devices. And so Wyeth was, from then on, had to put in their advertising what the side effects are. And this case is probably part of the law now, that when you see these ads, you notice there's a long list of side effects for any of these drugs, and that for any drug manufacturer who is advertising any of their products has to provide a list of these side effects. Now, the other chapter in this week's discussion, Chapter 9, you notice, is what's known as ownership and creativity. And the authors add intellectual property. And what we're discussing here is any kind of artistic development, any kind of artistic work, including music, writing, painting, any kind of cultural production by an individual. Their development is protected under the copyright provisions in the U.S. Constitution. And this is one of the few times that, believe it or not, the founding fathers, the developers of the Constitution, actually provided protection in the Constitution. And so ever since the beginning of our country, copyright material has been protected under the Constitution. And I want to quote you the actual part of the Constitution. Article 1, Section 8 reads that the Constitution empowers Congress to pass legislation to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And of course, when we're talking about copyright, what we're saying is, if you've developed some kind of independent work, whether it's a song or a poem, a novel, whatever artistic work that you have developed, you have the right to a copyright. And usually for a period of time, your artistic production is protected from anyone copying or interfering with your copyright. And it is protected by a natural section in the United States Constitution. Well, the first case that the authors use as an example is the MGM versus Gruniter. I think I'm saying that right, or Groster case. And you notice it was decided in 2005. Well, I mentioned before how the internet has had a tremendous impact on pretty much all areas of our lives. And here is one area where the internet has really impacted a certain segment of our culture. And this involves the copyright protection of music. And the case involves a company, if any of you are familiar with this, known as Groster. And I think it was a group of young guys who just came up with this idea of at that time, music was starting to be marketed electronically. You know, we've had records, we've had CDs. Now much of the music industry is produced through electronic media, through the internet and the various internet files for the production of music. Well, these individuals had the bright idea to start asking people to send in music files that they had. They would put them in a list, and then anybody else could go on the website and acquire this music without paying for it. And they were freely distributing these electronic files to subscribers of their website. Well, obviously the music industry, the major companies, were losing probably millions of dollars in lost revenue from their copyrighted material, and they sued Groster, and they won a ruling that Groster was violating the music company's copyrighted material, and that they were to cease and desist this activity, and that they were to no longer conduct this kind of activity. I'm sure it hasn't prevented the use of the copying of these files. I'm sure much of that is still going on, and the music industry has tried every kinds of ways they can to prevent the violation of these copyrights. Now, there is an exception in the copyright law for what's called a fair use. And what this means is that some individuals can copy certain copyrighted material for a very small group of people. I don't know if you're familiar with, but like myself as a college instructor, I can copy copyrighted material from anyone and provide it to my students, as long as that's all I'm doing, is I'm using it as a teaching tool to students. And that's what's called the fair use exception in the Constitution. Well, the Zomba versus Panorama case is an example where this has really been taken to the extreme. And the facts involving the case were that Panorama was a company that produced a kit that could be used at karaoke performances. And as you know, that's very popular in bars today, where someone can get up and pick a favorite song of theirs, and the lyrics are projected up on a screen, and this individual sings the song in front of the other patrons, and everybody gets a good laugh. Some are probably very good singers, and some of them are terrible singers. And so Panorama produced these products as part of a karaoke performance. Zomba held the copyrights to many of these popular songs that Panorama was producing. And Zomba sued Panorama that they were violating their copyright in the use of this karaoke machine. Panorama's defense was, no, we have a fair use exception to use this material for the limited idea of providing this karaoke material. The court disagreed with Panorama and said that they did not have a fair use exception. They were not covered under that, and that Zomba was awarded the judgment to prevent Panorama from distributing their product. You notice many of the manufacturers have got Congress to pass what's called the Digital Millennium Copyright Act to prevent this kind of violation of copyright. Now, I mentioned the companies have tried to prevent this, and Universal versus Corley is an example of this kind of case where Universal and other this involved the copyright of film production, that they had come up with a system that would scramble the signal to prevent individuals from copying the motion pictures that they were selling. Mr. Corley came up and developed a system that would prevent the scrambling. And he advertised in a newspaper how this was done and how you could prevent the scrambling and then receive the movies free without paying for them. Universal sued Mr. Corley. The court agreed that he was violating their copyright, and he was prevented from selling this. There are two other cases in the chapter. Let me cover them. I'm running a little late, but I do want to cover them just for your information. The White versus Samsung and Dosch Associates case is a very interesting case because from this standpoint, we're probably all familiar with Vanna White, who is the attractive woman that turns the letters on the game show and that Wheel of Fortune. And Samsung, the electronics company, with their advertising agency, Dosch Associates, developed an ad where a robot who looked like Vanna White was demonstrating Samsung products, with the theme of the ad being that Samsung's products would be used in the future, and when robots became common among individuals, that they would still be using Samsung electronics. Ms. White sued Samsung and Dosch that they were infringing on her likeness, her representation of her character on Wheel of Fortune, and she prevailed that they were violating her likeness and that they should no longer run these ads. The last case, the PepsiCo versus Redmond case, involves another area of copyright called trademarks. And as you know, this is very important for companies who have a product that they have developed and have sold and marketed. And PepsiCo is the company that owns the Pepsi products. Mr. Redmond was a high-level employee of PepsiCo, and PepsiCo made a sports drink called All Sport. And Mr. Redmond left. He had signed what's called a confidentiality agreement that if he left PepsiCo, he could not use this information with any other employer. Well, Mr. Redmond left PepsiCo and went to work for Quaker Foods, who owns a product called Gatorade that is a direct competitor to Allsport. PepsiCo sued Mr. Redmond to prevent him from sharing any of the secrets that he had found while employed at PepsiCo, and enforced this confidential agreement, and PepsiCo won the case and prevented Mr. Redmond from providing any confidential information to Quaker. Well, this will conclude the week 4 meeting.